All right, over here.
To what extent, I guess my microphone's working, to what extent is the analysis of the ethics of government attorneys affected by the more amorphous nature of the government attorney's client? That is, sometimes it's not clear you represent the United States of America when you go to court on behalf of the Justice Department, but you are also representing the head of the agency, but you are, as a practical matter, working with the offices of general counsel or the lower level political and or career people with whom you enjoy, for privilege purposes certainly and others, a client-attorney relationship. So given that the nature of the attorney-client relationship is fundamentally different for the federal government attorney, how does that impact how we look at the ethical obligations and potential violations or considerations of Rule 2.1 and others for government attorneys?
Yeah, I'll be brief. Others may have more to say about this. There's a lot of talk about the identity of government lawyers' clients, and there are all kinds of cases and comments on, is it the agency or the particular government actor or the executive branch as a whole or the people or something like that. I'm not engaging with that at all here. I'm keying the analysis to the nature of the legal entitlements that whatever the relevant actor is may have. And so I think I would kind of collapse those two questions down. But it's certainly worth thinking about in some context. There are cases in which it matters. I don't think this is one of them.
All right, over here.
I have a comment that I'd be interested in both panelists' responses. A great many people have decried the loss of civility and the growth of board king in judicial nominations and the like. And it strikes me that at some level an abstract debate about the rules of professional conduct are missing the threshold we're crossing right now, which is that, in my opinion, we are crossing a very, very dangerous threshold in how one administration treats the preceding administration. In my opinion, there are elements of the Democratic Party that are right now consumed by bloodlust and that are interested in taking officials from the preceding administration and nailing their hides to the wall and revisiting political disagreements. And that, in my judgment, if we go down that road, we won't be the first nation to go down that road. There have been banana republics.
Hey, hey, hey.
Okay, I think we've got the thrust of the question, so we'll
I know banana republics. Banana republics are my friend.
I respect that, but
okay.
my point being very simple. We are right now criminalizing policy disagreements. And if it becomes the precedent that each incoming administration prosecutes their predecessors, who in their right mind is going to go into administration and make legal judgments? In this instance, we're not talking about prosecuting people who are crooks, people who are taking bribes. We're talking about people who make policy decisions that their successors disagree with. And that prospect, going and putting your predecessors in jail, is an incredibly dangerous prospect for good governance going forward.
All right.
Is that, I guess that's the question to me. I must be the only Democrat in the room. So I count as an element of the Democratic Party, even though I have no organizational relationship. The hell, I'm not organized anyway. What am I talking about?
Neither are they.
Yeah. No, but I mean, look, of course that's the concern, right? I mean, I wouldn't be here if I didn't think there were some way of having this conversation in a way that wasn't just retribution or bloodlust. And there is a distinction. Let's take it out of the government context for a second. There are cases in which lawyers have been held criminally liable for aiding and abetting criminal enterprises. It can happen. Now, I'm not loading this up here and saying that's what's going on, but that is potentially the template for liability here. I'm only saying that it's possible in principle to evaluate legal advice and differentiate between legal advice that is in good faith and legal advice that is aiding and abetting criminal responsibility. I agree that it would be a terrible thing if this were just retribution and bloodlust. I think it's possible to have a neutral, objective conversation about this. And I actually think in the end, I don't know how these cases should come out. in terms of the substance of the underlying law. There may be so many close questions that discipline is not appropriate, criminal prosecution is not appropriate. That would be okay with me. I think the important thing is to have the conversation in the right way about the nature of the law. That's the only way I can think of to avoid the bloodlust problem. There may be others. The other would be simply withdrawing from discipline altogether. But if we're going to take seriously the possibility of enforcing lawyers' professional responsibilities, this is the only way I can think of to avoid that tit-for-tat, cycling, retribution, borking, whatever problem that we're concerned about.
Any response?
I mean, again, this is a problem of the general and the particular. I think that there is an answer to Ted Cruz, which goes something like, the other side, when they're starting, never think it's going to happen back to you. And I am sure that there is a number of elements in the Democratic Party who at present do not think that it will ever happen to Don Johnson, should she ever get confirmed, or to the Attorney General, or to anybody else. And that's true until, the independent counsel law turns on Bill Clinton. And then everybody says, gee, maybe this wasn't such a great idea, but there is a lot of interim harm. I do think, of course, that if you are talking about cases of criminality, where the criminality stems from evidence as opposed to objective disagreement with the four corners of the analysis, yes, of course, if you're the mob lawyer and you can point to what the evidence is, you have a very compelling case that you have engaged in a criminal conspiracy apart from the rules of professional responsibility. My issue with this is that we are nowhere talking about any of these questions. You can survey the entire body of literature that is critical of all of these opinions, and you'd be hard-pressed to find anything that is not simply the other side of an argument. And all cases usually have two sides for an argument. There's some that have more. And so it is literally impossible to craft a standard that departs from the unadorned text of the advice, and where the essence of the misconduct is to say, aha, I don't agree with you.
All right, next up over here.
Yes, I'm a lawyer, but I was an intelligence officer for 21 years, so I'll confess to some bias on this question.
Which way?
If memory serves, the preamble to the rules of ethics discuss the folly of launching ethical investigations in the context of litigation, and that the use of the rules of ethics for that sort of advantage, given the adverse state of the parties, is particularly suspect. Goes to the motivations of the grievant. And it itself can be an ethical violation, as I recall from the preamble. By analogy, given the adversity between political decision makers, between administrations that have changed, particularly where there's a change of party, shouldn't that same principle of restraint, suspicion of motivations, and potentially consequences for the grievant apply here?
What about it, Professor? Does that analogy work?
Sure, that analogy works. I don't think about it so much in terms of the rules of ethics, which you can file a grievance, but they're brought by a state bar disciplinary body, so they're not really under the control of the parties in quite the same way. They're like filing criminal charges. But it is certainly true of certain kinds of litigation sanctions remedies, Rule 11 and things like that. And federal courts were quite concerned for a while about the strategic or tactical misuse of Rule 11 and the satellite litigation that could result. And that is a problem, and this has to be kept under control. And so when there is an active dispute, there is concern that it will spin out of control with satellite litigation. And as a former litigator, I'm sympathetic to that. Again, this is sort of a rough analogy to say this is a political dispute, and therefore this is kind of satellite litigation in some way. I think that in some ways presupposes the conclusion, namely that this is a political dispute. If this were, now, I'm going to get killed by everyone in the room. If there were crimes going on, let's just say for the sake of argument that there were war crimes going on by U.S. government agents and lawyers provided advice that aided and abetted war crimes, then that's different from satellite litigation that distracts us from the underlying issues. That would be closer to a criminal conspiracy. I'm not saying that's what's going on, but I think a good faith reading of the people who are critical of the administration includes the possibility that there were war crimes committed and that some of the lawyers' advice could be construed under applicable international precedent as providing advice to facilitate the commission of war crimes.